Hi, this is Harvey Tettlebaum from Husch Blackwell. Husch Blackwell and his legacy firms have represented the Missouri Dental Association since 1977. We've been proud to be a partner with the Missouri Dental Association, and we're very pleased to be able to present this webinar on COVID-19 issues. We have two wonderful presenters. Kirstin.Salzman has been practicing law for over 20 years, and she is in our Kansas City office, and she has been involved in mergers and acquisitions and other legal issues, and she's part of our COVID-19 team that we formed at the time this legislation was first passed to be able to provide this expertise to our clients and to share this information with them. Co-presenting with her is Jenna.Brofsky. She's also in our Kansas City office, and for over 6 years she's been working in a lot of areas for employers, Title VII of the Civil Rights Act, Equal Pay, Americans with Disabilities Act, and she has likewise developed expertise quickly in this area to be able to provide this program for the Missouri Dental Association. So I will now turn the program over to Kirstin.Salzman.
Thank you, Harvey. As Harvey mentioned, my name is Kirstin.Salzman, and I am chair of the Husch Blackwell Corporate Mergers and Acquisitions and Securities Group. Like any good lawyers, we always have to start off a presentation with a disclaimer. The disclaimer is on the first slide, and it says the information contained herein is intended to be for informational purposes only. The contents do not constitute legal advice and should not be relied on as such. Specific legal advice should be sought on particular matters. We have reviewed your questions submitted to the Missouri Dental Association and have combined them in certain instances into similar topics to share the answers with you today. So with that, I am going to start out today. Our webinar is going to cover basically two topics. The first is the Family First Coronavirus Response Act, and Jenna will be addressing questions related to that. Those questions focus mostly on labor and employment issues. The other topic that we'll be addressing today are the Economic Injury Disaster Loan Program and the Paycheck Protection Program. Those questions are dealing with legislation that involves economic incentives and stimulus. So with that brief introduction, I am going to start discussion of the Economic Injury Disaster Loan Program, which I will be referring to as the EIDL program, and the Paycheck Protection Program, which I'll be referring to as the PPP program. I thought I'd start out with a very high-level summary of these two pieces of legislation to help frame the questions and provide some background. The Paycheck Protection Program is a part of the CARES Act, and it is being administered by the Small Business Administration. The loans come directly through commercial lenders, so if you have an interest in obtaining a Paycheck Protection loan, you need to reach out to your lender or a lender that is approved by the SBA. On the SBA's website, there is a list of approved lenders that should help you identify who could provide this financial assistance to you. At a very, very high level, the amount of the loan that you can get under the Paycheck Protection Program is equal to 2.5 times your average monthly salary for all your employees. And it is required to be used for payroll, rent, utilities, mortgage interest, and interest on other debt. There is a requirement that 75% of your loan proceeds be used for payroll. And the key point of this program and what makes it extremely attractive is it's eligible for forgiveness, meaning you don't have to pay it back if during the 8 weeks after you get the loan, you use it for payroll, rent, utilities, and mortgage interest. The forgiveness is subject to reduction based on reductions in the number of employees and wages. The EIDL program, switching over to that now, is a working capital loan. This program is unlike the Paycheck Protection Program, which is administered through commercial lenders, this is administered and the funds come directly from the SBA. So you apply for these loans directly on the SBA website. The loans are stated to be up to $2 million, but due to the high demand for these loans, it has been the SBA has restricted the amount of the loan to an amount equal to 2 months of the company's working capital, capped out at $15,000 per applicant. An attractive feature of this program is that when you apply for the loan, you can also apply for an immediate grant. Again, that grant was stated to be $10,000 at the maximum, but now due to restrictions on the use, limitations on the amount of money available, it is limited to $1,000 per employee. The key things about this program are that personal guarantees on loans under $200,000 have been waived. The SBA has also waived the credit elsewhere requirement. Usually on an SBA loan, you have to show that you can't get credit elsewhere. That test has been waived, and it is applicable for small business concerns. So with that general overview, I am going to switch over and start addressing each one of the questions. The first question up is, what is the status of the PPP program? Will more funds be available? Should I wait to apply for a PP loan when my operations begin again? And how can we find out the status of our loans? Right now, the PPP program is officially out of money. It was originally funded with $350 billion, and that money ran out last Wednesday. Congress is in the process right now of negotiating a bill to reload both the PPP program and the EIDL program with an additional, what I've heard on the street is an additional $310 billion to be split between those programs, mostly with most of the money going to the PPP. The question on whether or not you should apply for a loan now or wait until my operations begin with one is really a hard timing question. And the reason it's hard is because last time the PPP program ran out of money in 9 business days. And understanding that the forgiveness period is based upon use of the funds in the 10 days, or excuse me, the 8 weeks after the loan is funded, a number of companies have some hard decisions on what to do in this instance. My advice at this point would be to go ahead and apply for the loan, recognizing right now that there are no funds available, but if your bank will accept your application pending additional funds being available, I suggest people get in line for the money because we don't know when it's going to run out. In terms of how can you find out the status of your loans, the best advice I can give you is your banks. As I mentioned, the PPP is administered through commercial lenders, and so your bank should be able to provide you with status of the loans. Digressing a bit, I know this wasn't part of the question, but I do know a lot of people have been waiting and confused about the status of their EIDL loans and grants, and again, because that's administered through the SBA, it seems to be taking a little bit of time to get those funds processed and out the door, a little bit more time than it takes with a commercial lender. So be patient, and I suggest you reach out to the SBA with respect to EIDL loans. Next question. In determining the amount of my loan, my bank did not ask for rent or utility information. It only asked for my payroll costs. Can my PPP loan amount be increased to include rent and utilities at a later date? And the simple question to that is no, you can't. The PPP loan amount is based solely on 2.5 times your average payroll cost. And in determining that average payroll cost, you can use one of two periods. You can either use the 12 months prior to the application of the loan, or the average monthly payroll cost for 2019. So if you ramped up recently, it may make sense to use the 12 months prior to the loan, but the loan amount will not be, the loan formula will not be changed to increase it for rent or utilities without some sort of statutory change, which I do not anticipate at this time. The next question. The amount of the PPP loan that is forgiven is based upon payroll expenditures and other allowable expenditures during the 8-week period after the loan is funded. If the stay-at-home order is extended, do you foresee the SBA revising their guidelines to allow for the measurement period to be the 8 weeks after the stay-at-home order is lifted? The answer to this question is not likely, absent some legislative change. It is clear in the statute that was passed that the 8-week period begins on the date the loan is funded. So you would be a change in the statute would be necessary. Alternatively, and I don't want to raise anyone's hopes here, but the SBA has come out with a number of statutory interpretations that seem on their face to be contrary to the statute. There is a chance that the SBA could come out with a statutory interpretation to allow this to happen, but I don't think it's likely. I encourage everyone to, because this situation is extremely fluid and the SBA and the Treasury are issuing guidance daily, literally, I encourage everybody to go to treasury.gov. They have all the coronavirus rules, and particular of interest and to you all would be the Q&A, and that's being constantly updated, and that would be where I would go look to see if there has been a change in this 8-week period. Next question. If I take a PPP loan now, bring my employees back off unemployment, and after 8 weeks we still cannot work, can I put my employees back on unemployment and still be eligible for forgiveness? The answer to this question is most likely. Right now, the statute does not have any requirements on what you have to do after the 8-week period. I say that with the caveat of still 75% of the loan proceeds need to be used to fund payroll costs. My advice on this issue is if you find yourself in a situation where you need to put your employees back on unemployment, that you talk to your bank and make sure that they're comfortable with your plans so as to not jeopardize your opportunity for forgiveness. Next question. I have received my PPP loan. What can I use the funds for? Under the statute, the funds can be used for payroll and benefits, rent, mortgage interest, utilities, and interest on other debt. And I want to take a moment and address the mortgage interest component of this. A lot of people are asking, is that interest on loans secured by real estate or loans secured by personal property such as cars or office equipment? And right now, I think it is unclear. There was some guidance that has recently been issued with respect to employees who are self-employed, that the funds can be used to make interest payments on loans secured by personal as well as real property. I don't know if that will hold true for small businesses as well, but it provides some hope. And again, look at the Q&A on the Treasury website for updates with respect to that. I also want to take a moment and stop on the fact that interest on other debt incurred prior to February 15th is a permissible use of the loan. However, if the amount is used to pay that interest, that amount is not eligible for forgiveness. Next question. Can employee insurance that was paid for them while they were on unemployment be part of the 75% that is required to be used for payroll, and can it be forgiven? The answer to that is it appears yes. Insurance costs are part of payroll. So it appears that amount is eligible for forgiveness. Just as a point of reference, forgivable payroll costs also include retirement benefits, payments for vacation, parental, family, and sick leave, but please note that you cannot include sick and family leave wages as forgiven if you get credit for those through the tax program, through the Families First Coronavirus Act. One of the topics that you'll see here, or themes that you'll see here, is there can't be double dipping. So if you're getting a tax credit for sick and family leave, you're not going to be able to get that amount forgiven as well. Next question. How long do I have to use the PPP loan proceeds in order for them to be forgiven? And it is clear, as I mentioned earlier in the statute, that it's the 8 weeks after the origination of the loan. And a reminder that 75% has to be used for payroll, and the other 25% can be used for the other permissible uses. Next question. What happens if I do not spend the entire amount of my loan in the 8-week period after it was funded? In that instance, if you don't use all of the money in the 8-week period for permissible uses, that means that it's not eligible for forgiveness. And any amount unforgiven turns into a loan. This loan will carry interest at 1% and will be a 2-year loan. Some of the banks are saying it's a 2-year bullet loan, but most of them are saying it's a 2-year loan with monthly payments of interest and principal. The interest and principal, however, will be deferred for the first 6 months after the loan is originated. And it's important to note that these loans are not recourse, there are no prepayment penalty, and there's no requirement for a collateral or personal guarantee. So these are 1% unsecured loans. Next question. What is the maximum amount I can receive under the EIDL loan? As I mentioned earlier, that the initial eligibility was up to $2 million, and now it's been capped at 2 months of working capital, capped at $15,000 per applicant. And I know with the new anticipated legislation coming out, that may change by the end of the week. And also I want to note that under the EIDL loan program, remind everyone that there's an eligibility for a grant. And that grant is now $1,000 per employee up to $10,000. Next question. Can I use my EIDL grant for dental supplies, office supplies, and have forgiveness of that loan? A couple of things that are important to note here. The EIDL loan is not a forgivable loan. And in fact, the EIDL grant portion, the $10,000 that's eligible for grant, actually reduces the amount of forgiveness if you get a PPP loan. In terms of what you can use the EIDL loan for, as I mentioned, it's eligible to be used for working capital. It can be used for fixed debt payments, such as rent. It can be used for payroll, and I'm going to put an asterisk by that for a moment. Accounts payable and other bills that can't be paid because of the disaster's impact. And we'll address the payroll issue on the EIDL loan in a later question. What this loan cannot be used for are dividends, bonuses, disbursements to owners, unless it's for otherwise for services in terms of salary. You cannot use it for repayment of shareholder loans, with certain exceptions, for any expansion of your facilities or acquisition of fixed assets. It cannot be used for repair or replacement of physical damage to assets, and it cannot be used for relocation expenses or repayment of other long-term debt. Again, primarily working capital. What documentation will I need to show to obtain loan forgiveness? Under the statute, right now it's saying that the document that's going to be required is you're going to have to submit documentation verifying the number of full-time employees on your payroll and the amount that you pay to them. And the way the statute suggested this gets done is through IRS payroll tax filings or state or local income payroll unemployment tax filings. For the mortgage, rent, utilities, and interest, you're going to have to show clear documentation on what those amounts were paid for, whether that's through canceled check, payment receipts, transcripts of accounts, or other documents. To this end, to be able to fully document what you use the funds for to obtain the maximum amount of forgiveness, it's strongly recommended that you keep the money in a separate bank account or at least a separate ledger item in a bank account so that you can clearly and accurately trace and prove what every cent was used for. I think this is an area where precision is going to be mandatory to be able to obtain the maximum amount of forgiveness. Next question. I have been approved for a PPP but do not have my money yet. Can I pay my rent and utility bill and then pay myself back once I actually receive the money? The forgiveness is clearly based on the costs incurred and payments made in the 8 weeks after the loan. So I would strongly recommend that you not do that because I do not think that that would come under a forgivable use. It's a permissible use, but I don't think it will be forgiven. So I would strongly discourage that. Next question. What is the interest on an EIDL loan? And this is a straightforward question, which is 3.75% for small businesses. So it's not as attractive as the PPP loan, which has a 1% stated interest. Next question. My staff has decided that they would rather take unemployment, so I have no payroll cost to pay for my PPP loan proceeds. Is it possible that the PPP loan will be forgiven if we use it for rent or other permissible purposes and not payroll? And the answer there is no. The SBA was very clear that of the forgivable amount, only 25% can be used for other permissible purposes. You have to use 75% for payroll. And I note there real quick, there is no prepayment penalty. So if somebody feels they're in a bind and they don't want the money because they don't have a use for it and don't want to have to pay it back, incur the interest, you can pay back the amount. Next question, how is the forgiveness calculated if I cannot keep my entire staff for the 8-week period? What happens if I reduce their pay? Can I bring them back and increase the amount of my loan forgiveness? And the answer there is the loan forgiveness, as I mentioned earlier, is reduced if you reduce the number of employees that you have or if you reduce their wages. And there's an exception there that you can reduce wages of people that make over $100,000 and that will not impact your forgiveness amount. The loan forgiveness on the employee component, the number of employees, is reduced by a fraction or a ratio or percentage, which is the number of employees, full-time employees that you have during the 8-week period of the loan compared to the number of employees during one of two periods, which is either February 15th, 2019 to June 30th, 2019, or January 1st, 2020 to February 29th, 2020. If you lay off people between February 15th, 2020 and April 26th, 2020, or reduce their wages, and those people are brought back or their wages are restored, you get a credit for the reduction in your loan forgiveness. This loan forgiveness calculation is very complex on its face. Right now there's little guidance, and my advice here would be to contact a lawyer or your banker to help you get more detailed and definitive guidance on how to manage through this forgiveness calculation. Next question, if I receive a PPP loan, can I require the employees to put in some working hours with something other than patient care instead of just staying home? And the answer is yes. I mean, you can require your employees to do things that are typical and standard to their employment. I've heard of people requiring some training, requiring maybe some cleaning or other tasks that always are on the list to get done, but sometimes get forgiven in the rush of day-to-day business. And the last question, if I received an EIDL loan and a PPP loan, can the EIDL funds be used to offset payroll expenses that occurred prior to the distribution of the PPP loan? And this is the question I put the asterisk by earlier. The answer there is yes. You can use the EIDL funds to offset expenses that occurred prior to the distribution of the PPP loan. And you can get an EIDL loan and a PPP loan at the same time. What you cannot do is use the proceeds of the loan for the same purpose. So it's again that double dipping concept. You can only use the monies for one of the identified and permissible purposes. And with that, that is my last question. I just want to say, take a moment and say thank you very much for the time that you spent. And if you have any other questions, please let us know. And with that, I'm going to turn it over to Jenna, who will address the employment issues.
Thank you so much. This is Jenna.brofsky, and I'm an attorney in Husch Blackwell's Labor and Employment Group. And I'm going to talk through some of the employment issues that have arisen in the context of COVID-19. And so the first question is, how does the new federal legislation, specifically the FFCRA, affect employers and employees? So the FFCRA is the Families First Coronavirus Relief Act, and it's that piece of legislation that requires covered employers to provide paid sick leave and extended family and medical leave to employees for certain enumerated reasons. This leave is funded by the federal government, so practically speaking, employers can defer payroll taxes and can file for advance payment to qualify to cover qualifying leave payments. Who is covered? Employers with under 500 employees. Notably, there is a health care provider exemption. And the term health care provider is broadly interpreted by the Department of Labor, and it includes dentists, and it also includes, per Department of Labor interpretation, anyone employed at a dentist's office, the hygienist, the receptionist. Under this exemption, the employer can choose whether they're going to exempt their employees from receipt of the paid leave. It's worth noting that at the time of recording this webinar, there's at least one lawsuit that's challenging the scope of the exemption, so it's important to stay tuned for that. There's also a small business exemption that exempts employers with under 50 employees from providing the extended FMLA benefits, but not the extended paid leave benefits. As Kirstin noted earlier, employers cannot double dip and cannot use PPP loans to cover the paid leave that they're providing, for which they've received a tax credit under the FFCRA. Also, Missouri has passed an executive order temporarily waiving the charges to contributing employers for unemployment benefits paid to claimants as a result of loss of work due to COVID-19. Okay. Next question. Under what circumstances could I, the employer, be liable for employees contracting COVID-19 at the workplace? And so really the question is about where employers could be exposed to liability should an employee develop COVID-19. And the first area to be aware of is workplace safety, and that's governed by the Occupational and Safety Health Administration, or OSHA. And under Section 5A1 of the Occupational Safety and Health Act of 1970, employers have a duty to provide employees with a place of employment that is, quote, free from recognized hazards that are causing or are likely to cause death or serious physical harm. So employers should be aware of this obligation under the General Duty Clause to protect workers from certain hazards, including if you know an employee has COVID-19, sending that employee away from the workplace. Per OSHA, employers should be performing a hazard assessment to identify hazards and to provide PPE, personal protective equipment, where needed. There are actually several OSHA standards that apply to dentists, and more information about that is available on the OSHA website. OSHA also has a whistleblower non-retaliation provision. So employees are protected from adverse actions like terminations for complaining in good faith about unsafe or unhealthful conditions in the workplace. So the second area of potential exposure, in addition to workplace safety, is workers' compensation claims. Generally speaking, an employee has the burden of proving that his or her illness was the result of exposure sustained in the course of employment. We've seen a shift in that burden in other states, and in Missouri, there's been a shift as refers to first responders, but it's important to stay tuned as to any changes in workers' compensation law. The third area of potential exposure is general tort law. So that could be negligence claims alleging an employer fails to meet a reasonable duty of care to the employee. And kind of the last area that we should be thinking about is just general discrimination law, which prohibits discrimination based on a disability, or if an employer is providing any of the leave under the Families First Coronavirus Relief Act, there's also a non-discrimination, non-retaliation provision contained in that legislation as well. Next question. Can I have my employee sign an acknowledgement or a waiver of liability regarding exposure to COVID-19? So what is a waiver? It's a voluntary relinquishment or abandonment of a legal right. Employees cannot waive their right under the OSHA General Duty Clause that we just discussed, or under any OSHA standards, so a relief would be ineffective. Next question. Can I have my patient sign an acknowledgement or waiver of liability regarding exposure to COVID-19? So this is a related question outside the employment relationship, but about patients. And so the CDC, the American Dental Association have all recommended screening of patients telephonically before bringing them into the office. Additionally, patients are given informed consent, hopefully each time they're being treated, and COVID-19 exposure is something that could get wrapped up in informed consent, although that may not eliminate all claims. Whether a patient waiver of liability for exposure to COVID-19 would be enforceable remains to be seen. There are some public policy implications there and some limits in Missouri to the type of conduct that can be waived. Okay, next question. When should we bring our employees back to work? I can't give you a definitive answer, but when doing so, safety should be the priority, and employers should be following guidance from the CDC, the Missouri Department of Health, and any Missouri stay-in-place orders. As folks likely know, the Missouri stay-at-home order is currently in effect until May 3rd, but different municipalities like Kansas City, Missouri, and St. Louis have their own stay-at-home orders. President Trump recently rolled out some guidelines called Opening Up America Again, which are really just some things for employers to keep in mind, and specifically the readiness of your workplace before bringing folks back, including availability of personal protective equipment. Has cleaning been done? Is the physical space prepared? And are there policies in place to deal with questions that arise? Returning employees to work in phases is also something that we're seeing and recommending, both in terms of who's in the office at the same time and also assigning operatories to one provider to avoid exposure by the providers. Next question. During the time our office is closed, are we allowed to have employees come into the office for training? So the general guidance from public health community, federal government, and state government is all to stay home, social distance as much as possible. The actual Missouri stay-at-home order allows entities that employ individuals who perform essential worker functions as defined by federal law to remain open, and that includes healthcare workers. So dental offices can remain open, but the next part of the Missouri stay-at-home order is relevant. It says, quote, for offices and workplaces that remain open, Individuals shall practice good hygiene and, where feasible, work from home in order to achieve optimum isolation from COVID-19. So if this training is something that could be done at home through a conference call or virtually video conferencing, that would seem to be in line with the spirit of the order, and practically speaking, may reduce some of the concerns and anxiety coming from staff. Okay, the next topic within labor and employment is employee terminations, and this question states, suppose some of my staff refuse to work when we restart our patient schedule. Can I terminate their employment? Have they effectively quit at that moment? They fail to report to work without explanation. And what, if anything, should I do to formalize or document the separation? So let's talk a little bit about end of employment. If an employee has a contract, the employer should consult that contract to determine what constitutes a termination and if there are any specific requirements. Of note, if there's no contract, then the default employment relationship in Missouri is at will. And at will means that employers and employees can terminate employment at any time for any lawful reason, including the employee's failure to perform their job duties. Employers cannot retaliate against employees for making a good faith complaint, and in some cases, refusing to work because of a hazardous working condition as defined by OSHA, which is part of why it is so important to have done a hazard assessment for an employer to have drafted a preparedness and response plan and comply with OSHA in advance of reopening their office. In an at-will employment relationship, the employer doesn't have to wait until the patient's schedule starts again to end an employment. That can be done for lawful reasons at any time, although there may be other reasons, economic or otherwise, as to why an employer would want to keep an employee employed. There could also be other risks associated with an employment termination. And if an employee is refusing to work because she has a disability that could be worsened by exposure to COVID-19 and the employer knows that, the real question is the employer engaging in the interactive dialogue with that employee, seeing if there is a reasonable accommodation per the Americans with Disabilities Act? So the circumstances around why the employee is refusing to work are really critical here. In terms of documentation, and under an at-will employment relationship, there's no need to provide anything to an employee in writing at the time of termination other than as otherwise required by COBRA or your own internal policies and handbooks. Best practice is to have a conversation with an employee, make sure everyone understands what's happening, and to at least document internally that there's been a termination. Okay, the next question, kind of similar, an employee verbally advises she is not coming back to work when we reopen to see patients, claiming she needs to take a family member or to a doctor appointment. Despite my request, she has not provided any written notice of quitting. What is my financial obligation to her? So again, employees with contracts, we should be consulting the actual terms of the contract or agreement. Assuming this is an at-will employment relationship, generally an employee expressing her intent to quit is sufficient to end the employment. Nothing needs to be provided in writing by the employee to the employer. However, here it would seem that this employee might be asking for leave or an accommodation. So if an employer has a policy preventing sick leave, make sure that you're applying it even-handedly. And if you're providing leave under this FFCRA, you can't retaliate or discriminate there for taking leave or seeking leave. Now, to the extent the employment ends, the employee should be paid for all hours they've worked in compliance with the Fair Labor Standards Act. In Missouri, there's no requirement to pay for unused vacation time unless the employer policy otherwise requires it. Missouri law does require employers to pay a discharged employee all wages due at the time of dismissal. Okay, and now we're heading into our last big topic here, unemployment. This question is, my staff have announced en masse that they would rather take their unemployment check instead of remaining employed, as they may receive a higher weekly amount that way. So how do I respond? So let's just talk briefly about unemployment. States administer their own unemployment compensation systems subject to federal guidance. Now, one of the new pieces of federal law, the CARES Act, expanded upon that in certain ways, but it did not, at its core, affect the situations that warrant unemployment. So to be eligible for unemployment, the person has to be unemployed through no fault of their own or quit for good cause as defined by law. So no fault of your own would be if a hygienist is separated because there's no patients coming in, so there's no work for her to do. As to quitting for good cause is defined as cause which would compel a reasonable employee to cease working or which would require separation from work due to illness or disability. So the standard is objective. It's based on reasonableness and good faith by the employee, and the determination is made on a case-by-case basis. And the employee is the one who bears the burden to show good cause for quitting and therefore eligibility for unemployment. Now, per the Missouri Department of Labor, if the employer offers sick leave or other leave or remote work to address COVID-19 in lieu of layoffs, then a person who quits of their own volition will not qualify for unemployment benefits. Further, quitting without good cause to obtain the additional funds under the CARES Act qualifies as fraud per the Missouri Department of Labor. So while employers should not be in the business of advising staff as to whether to apply for unemployment, it is good to understand what the eligibility requirements are for unemployment. And further, there may be perks or incentives for employees to stay employed, including if employers are considering continuing to provide health insurance or other benefits. Next question. Are LLC owners eligible for unemployment? So under Missouri unemployment law, self-employed individuals, like owners of LLCs, are not covered, but Section 2102 of the CARES Act creates a temporary unemployment assistance that covers a broader swath of people than the Missouri unemployment system. And that's called the Pandemic Unemployment Assistance Program, the PUA, and that includes people who are self-employed. So it's a federal program, but it's administered through the states. So there's a little bit of a delay here in the states, including Missouri implementing it. Missouri has stated that this week, the week of April 19th, it's going to provide more information as to PUA, but folks who are self-employed should still apply and will in fact receive notice stating that they do not qualify. That's kind of a prerequisite to receiving the PUA. And then once Missouri has figured out how to implement its PUA program, then the Missouri Department of Employment Security will reach out to folks who've received an initial letter saying that they don't qualify. The PUA will be retroactive to when the employee was negatively affected by COVID-19, but the individual will need to provide proof of that. So the next question is, what proof do I need to verify my income for unemployment, as I am a self-employed dentist and have not yet filed my 2019 tax returns? So as noted, this guidance from Missouri is being updated almost daily, so it's important to check out the Missouri Department of Labor website for more information. But the Missouri Department of Labor has said that proof of employment must be provided by those who are self-employed and seeking PUA, and employers can, quote, choose to provide proof of earnings to potentially increase the amount of benefits they're going to receive each week. Normally, tax forms for a recently filed tax year work. And in the related context of disaster unemployment assistance, the Missouri Department of Labor has accepted signed statements of earnings or net income for most recently filed tax years. So this is kind of a moving target and something to stay tuned for more information about on the Department of Labor website. Okay, next question. I work for an SQHC and was laid off because they can't afford to pay us without production. Is there anything in the new federal legislation that would help me and my family? So first things first, if you're laid off, you're not eligible for the new paid leave provisions under the FSCRA, although that's somewhat also being interpreted or challenged in court at the moment. But someone without a job due to COVID-19, through no fault of their own, can apply for unemployment. And what is changed under the new federal legislation for those who are unemployed through no fault of their own is the amount of money that the person is going to take home. So Missouri has a formula to determine the weekly benefit amount, which is based on how much the person was making in the past. And on top of that, under the new federal legislation, those who qualify will receive $600 a week. The CARES Act also provides certain eligible taxpayers with refundable tax credits depending on income level and family circumstances. Further, the Missouri Department of Social Services has information about food assistance, cash assistance, broadband access, and other information on their website. So stay tuned for changing or additional federal legislation and state legislation, as this is a changing landscape at the moment. So that concludes the section on labor and employment. Husch Blackwell has a plethora of resources for businesses and employers on COVID-19, on the different aspects of federal law and changes to state law. And we are happy and available to help answer questions and work through different scenarios. Our contact information is located on your console, so please do reach out to any of us, and we're happy to provide advice. Thank you so much, and this concludes the program.